Even I don't know. Just wait for a while.
Yes. Well,
Yes.
His Lordship, my Lord, I beg to mention item number 10. My Lord, here I'm yet to file affidavit, so kindly allow me 3 weeks time, Lord.
Here for the government,
State, yes, my Lord.
on a request made by the Learned State Council, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Yes.
Lordship,
Much obliged.
interim order passed.
Okay, interim order passed earlier to continue till the next date of listing.
Much obliged.
Lordship.
So Lordship, I beg to mention item number 13, Your Lordship.
Yes,
Lordship, I'm appearing for response numbers 6 to 12,
yes.
14 to 20,
Hmm.
22, 23.
Yes, we have seen, yes. You have not filed your affidavit in opposition?
Yes, Your Lordship. I may be allowed 3 weeks time, Your Lordship.
Madam, Jimam, you are for the petitioner here.
I am for the.
You were supposed to file an application for deletion of names of the petitioners, few of the petitioners.
They engage another lawyer.
Okay. So the petitioners are fighting among themselves. You should unite and fight against the respondent.
Lordship, here there are some unwanted elements. I won't say more.
Your clients.
Yes, Lordship.
Your clients are the unwanted elements.
No, there was some propagandas and.
Yes, well, what about your application for deletion? Yes, you wanted to delete a few names, you had filed your wakalatnama, you had made a submission. When? When was the last date when the matter had? You need to all the petitioners to come here to file an application. You should have filed it. You had made a prayer and there is a confusion who is the lawyer of the petitioner. So you better do it. And madam, how much time do you want to file? For 3 weeks, we have to file your affidavit for deletion. Okay. On a request made by the Learned State Council, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Your name, please? Sri so-and-so learned counsel, who appears for few of the petitioners, is also required to file the application for deletion of certain names of the petitioners, which was submitted on the last occasion. Yes.
Highly obliged.
Is there any interim order?
No, no interim lordship. Obliged lordship.
Maps Lordship. Lordship, I think mentioned it 17 and 18.
Hmm.
Here I'm led by my senior Mr. P.B. Paul.
Hmm.
He's not keeping well, so Lordship, if the matter can come up to 3 weeks, Lordship.
Okay, 23 matter, you
Yes,
cannot, we'll accommodate you, but take care. Huh?
Lordship, kindly, Lordship.
Enjoyment is not desired. So, this court has, it is submitted that Sri P.B. Paul, the learned counsel for the petitioner is unwell. Petitioners in these cases are unwell. And therefore, a prayer for adjournment has been made. Also heard, Ms. So-and-so, the learned state counsel.
Lordship.
Para? In view of the above, matters are adjourned by 3 weeks for hearing.
For hearing, Lordships. Bless me.
May please Lordship. Lordship, I beg to mention item number 2
Yes.
on behalf of H. Hearing. Lordship, kindly list this matter after 2 weeks.
Item number 2.
Lord.
Affidavit filed by the respondent number 5. 1 and 4 has also filed. Reply filed against 1 and 4. You need to file, who is for the petitioner?
Your Lordship, I'm for the petitioner.
You'd like to file reply to the affidavit of respondent number 5?
Your Lordship, pleadings are completed.
No, against 5 you have
No,
not
no.
filed. You are not required, you will not file.
Required. Yes, Your Honor.
And why do you want time today?
Lordship, it's a joint prayer, Lordship.
No, why?
Lordship, the council had read this matter is, she have some personal difficulties, Lordship.
Council is in some difficulty. Okay,
Lordship.
okay. I will. Bring the file. In the index, it's not updated. Please tell, because this affidavit in reply filed by the petitioner against 1, 2, 3, 4. 1, 2, 3, 4, there's a reply affidavit also. It's not been updated. And this was done when 27/6. Please ask them to update. Oh, this is the purpose. On a joint request, consideration of this matter is deferred by two weeks.
Your Lordship, if we could kindly have it on the 3rd of November.
On a joint request, the consideration of this matter is deferred. Full stop on request, no, at least on 3rd of
November for admission hearing.
3rd of November. Is it auspicious or what? It may be auspicious for the respondents.
Your Honor, on the
Third-
2nd week of,
3rd of November?
yes, Your Honor.
3rd of Monday, okay. 3rd of November. Next Monday,
Yes, Your Honor.
okay.
Applies, Your Honor.
Lordship, I also like to beg to mention item number 8.
8 years.
Lordship, on behalf of Libika.
You have not filed your affidavit of opposition.
Lordship, she's yet to receive instructions, so if 3 weeks time, we kindly grant it to me.
Okay. On a request made by the learned state council, matter is adjourned by 3 weeks to enable receiving of instructions / filing of affidavit of opposition. Yes.
Lordship, item number 9 as well, similar prayer.
Why are you mentioning all the matters? What will you do? 9, same. Same period, 3 weeks. There are no interim orders in these cases. Are there any interim orders?
I place, Lordship.
May I please, Your Lordship, I beg to mention admission item number 4. Lordship, I have an instruction to appear on behalf of Pravir Chowdhury. He is indisposed, so kindly list this matter on
But
18.
how are these writ maintainable?
Lordship, I'm not in this case. I have an
You are
instruction.
a
to appear on-
hereby closer of a bank guarantee. How do you come to a writ court? You can go to the civil court. Even the next case, for non-extension of the loan facilities by a bank, you cannot come to a writ court. Okay, we'll accommodate you. When you pray for a date or what?
Yes, Lordship, on 18 November.
18 November.
Yes.
This court has been informed that Sri P. Chaudhary Learned Counsel who's the learned, informed that the leading counsel Sri P. Chaudhary is unwell. and therefore a prayer for accommodation has been made, para, on request list on
18 November.
18. Now you have informed the other side.
Lordship,
Oh, yeah.
you're
For the bank.
I'm for the bank.
Okay.
My appearance will be reflected, Lord.
Yes, yes. Sri so and so, please give your name.
Foseko.
Is present for the respondent bank.
Lordship.
There is an
Oh, the-
interim, Lordship.
Interim is also there.
Yes.
Interim order stands what? Vacated.
Lordship, I'm not in this case.
So it should
I
be
just have
vacated.
an instruction to appear
It needs to be extended or vacated.
Extended.
extended, Lordship. Yeah.
Interim order stands extended till the next date of listing.
Some prayer for item number 5.
Yes,
Right, yes.
right.
Yes,
5, there is an interim order.
Yes, Lordship.
Separately.
Highly merciful, Lord.
Much
Um,
obliged.
You appear in 5 also.
Yes, Lordship, for the bank.
Okay.
Now, please, Lordship. Lordship, I beg to mention item number 12. You have instruction to appear for respondent number 8, 9, and 10 for the private respondents. So I will be given at least 4 weeks' time to find my
Also, what about 11? 11 also.
8, 9, 10, 11.
8, 9, 10, and 11. Here for the petitioner.
Yes, man.
You are seeking appointment for land donation. Appointment in lieu of land given.
My lord.
Okay, Sri so-and-so Learned Council has submitted that he has entered appearance on behalf of the respondent numbers 8-11.
8, yes.
8-11. He prays for and is accordingly granted 3 weeks' time to file affidavit in opposition.
Lordship. Highly merciful.
Item number is 12. You write first, seen the office note as per which service report upon respondent numbers 8 to 11 is awaited. Full stop. However, Sri so-and-so Learned Council has that he has entered appearance. Okay.
Highly merciful, Lord.
May I please, your lordship? Lordship, I beg to mention item 3.
3 years.
Yes, here the state had taken leave last time to go for verification report from the DC.
Yes,
That
correct.
report is still awaited, your lordship. So we pray for 3 weeks.
What about the affidavit?
Yes, as per that report, we'll be filing our.
You need to file affidavit 24 matter. More than a year has passed.
Yes, your lordship.
This is also appointment in lieu of land.
Land ownership,
Yes.
yes.
Okay. Yes, what do you say, madam?
Oh, I have no objection.
Okay. On a request made by the Learned State Council, matter is adjourned by 3 weeks to enable filing of an affidavit containing the verification report.
Your lordship.
Interim is there.
Interim order passed earlier to continue till the next date of listing.
Your lordship, I have a similar prayer for 3 weeks for items 6 and 7, your lordship.
Oh, no items will be left.
I still have.
We need to do some cases. Roads are also very bad.
Yes.
We had a tough time traveling to
True, your
Kohima.
lordship. The state is yet to file an affidavit, your lordship.
Item 6 and 7.
Yes, your lordship.
6 and 7.
6, what is 6?
Both are land ownership appointments.
But 7, you have got 6 chances. 6 opportunities were granted to you to file affidavit.
Yes,
Still, you have not filed. 7 will give you a last opportunity.
your lordship.
Okay?
Not
Item
yet.
number 6.
In item number 7, there is an interim too.
Okay, 6, huh? 6, on a request made by the Learned State Council, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. 7, you write. A prayer for adjournment has been made by the Learned State Council to enable filing of affidavit in opposition. Full stop. This court has, however, noted that 6 numbers of opportunities were earlier granted to file affidavit. Full stop. Considering the above, a last opportunity of 3 weeks is granted to file affidavit in opposition. List after 3 weeks. Para. Interim order passed earlier to continue till the next date of listing.
Oblige, your lordship.
May it please your lordship, I beg to mention item number 11 on behalf of Laknepom, your lordship.
Yes.
Since he's disposed, I'm asked to take 3 weeks time, your lordship.
Item number 11.
Yes, your lordship.
IA to implead finance not filed. You have to file an IA for impleading the finance department. For that, you don't need to seek time. You should have filed an IA. For arguing, the council may not be keeping well, but to file it, you should file an IA for implement. Should not get matters deferred like this. This court has been informed that the leading counsel is unwell. Full stop. It also appears that the IA for implement has not yet been filed. Para. In view of the above matter is adjourned by 2 weeks to enable filing of the IA. Please file it.
Yes, your lordship.
I oblige.
Much obliged.
Please, Your Lordship, I beg to mention item number 19 on behalf of Mr. Tushio Olonkumer. The leading counsel for the petitioner is indisposed, so I pray that the matter may be listed after 2 weeks.
Yes, government. Okay. The learned counsel for the petitioner is said to be unwell. Para. List after 2 weeks.
Much obliged, Your Lordship.
Item number 19. Huh?
For admission, item number 1.
Your lordship, if 2 weeks' time may be given to us to file our reply, your lordship.
You could have mentioned it.
Since it's.
You thought
item
too many
number-
mentions, so better the item should reach. Good
Okay.
decision, by the way. So here you have not filed the reply affidavit
Yes,
on a request made by the learned counsel for the petitioner. 2 weeks time.
2 weeks' time.
2 weeks time is granted to file the rejoinder affidavit. Okay.
Much obliged.
Rejoinder affidavit against the affidavit of the respondent 4.
Yes, yes.
4 or whom? 3? Whom? Okay, don't say anything. Rejoinder affidavits.
For hearing, item numbers 14 and 15.
Which one would you like to take up, Mr.
The
Jimo?
first one, Mano?
First one.
Yes, first one.
5050.
Yes, Mano.
And in the first petition, there are 2 petitioners.
Yes, my lord.
And in the second one, there are 11 petitions.
Yes, my lord.
Both the petitions are connected.
Both the petitions are connected and
They were dismissed, reinstated. Now you are seeking the MSCPs.
yes, my lord.
What is the difficulty?
The not just the MSCP, your lordship, the break has been treated as absence from duty,
Okay.
no increments.
Okay. You
So-
want a prayer for regularization of that period?
Yes, my lord. And what short point, your lordship, an order of DS none can only be applied through a disciplinary proceeding.
Yes, what is the difficulty? Can we come to a consensus?
Lordship may kindly.
Unless you argue that there's a law point involved.
Lordship,
Yes, you may have a point so far as the back wages are concerned, that
Lord.
we may agree with you
Lordship.
for the period for which they have not rendered.
Yes.
But can you deprive of the service benefits for that period, including MSCPs, fitment, seniority? Back wages, we may,
We are not claiming that, my lord.
we may have certain reservation on the doctrine of no work, no pay. But other benefits, how do you deprive?
Lordship, basing on the order dated 27 August 2018, Lordship, there is a specific this observation given by the Directorate of Health and Family Welfare, where they have stated that the incumbent will not be entitled for any.
That is the subject matter of challenge.
Lordship, that is.
Once you reinstate, first you dismiss them. You
Lordship,
may have good reasons to dismiss, but there's an order of this court
Lordship,
pursuant to which you reinstate them.
Lordship,
For that period, when they were out of service, you may take a stand that they may not be entitled to the wages because remuneration, because they have not served. But since their dismissal has been interfered by this court,
Lordship.
it goes back to the date when they were
Absolutely.
dismissed from service.
Lordship,
And once it goes back, the continuity you cannot break, there cannot be a break in the service. That is what the
Yes, ma'am.
service jurisprudence is. If you have any other point to argue, you can argue, we'll consider, but that is what we think.
Lordship.
And these matters are pending since 2021.
Yes, ma'am.
They're fighting since long. This should come to an end. This is what we have just seen from,
Yes, Lordship.
we have not gone in details. If there's a requirement to go in details, we'll go. Otherwise, if this is what
Lordship.
falls from the
Lordship,
court,
Lordship.
and
There's no need.
Jimomi has very fairly said that he's not even claiming for the back wages, then we can pass an order.
Lordship. I leave it is. Lordship.
Ultimately, justice has to be done to all, to
Yes,
the state, to the individuals. You also cannot be burdened with to pay them salaries for the period which they have not worked. We'll
Lordship.
balance it.
Lord.
Have you made a short kind of a synopsis, Mr. Jimomi?
Yes, my lord. Your lordship, synopsis is there in the
No,
first page.
that is for presenting the writ petition.
Yes,
For the purpose of
otherwise,
this,
no,
for
ma'am.
purpose of disposal, we could have,
I have not.
because we just had a glance of the file.
Otherwise, I can make it a supply to her. And please.
We can dispose both these petitions.
Yes, my lord.
But
I'll
we can
make
still do it right now. There's no difficulty. But we need to be very clear on the facts, dates.
My lord.
Okay.
My lord.
We'll do one thing. Let's have a small hearing. I think that will be better.
My lord.
You can just place the facts.
My lord.
You can also assist the court by furnishing a synopsis tomorrow, but we'll try to have it today itself.
Yes, my lord.
Please.
My lord.
First we are at 50.
Yes, my lord.
50 of 21, two petitioners.
Yes, two petitioners.
Yes.
And your lordship, the details of their entry into service is paragraphs 2 and 3.
What did they do? Multi-scale. What was their duties? Their occupation, the job?
Surveillance worker.
Surveillance.
Surveillance worker. One is surveillance worker and the other is female attendant.
Female attendant.
Petition number 1 is surveillance worker.
P1.
Yes, madam.
And P2?
P2 is female attendant.
Both in the health department.
Yes, in the office of the CMO worker.
Female attendant.
In the office of the CMO worker.
Chief Medical Officer.
Yes, my lord.
Okha.
Chief Medical Officer worker. And they were the P1 was appointed by order dated 23/6/2008.
First one.
Yes, my lord.
23/6/2008. And
P2 was appointed by order dated 12/12/2007.
Basically, no problem. About 10 minutes. Yeah.
P1's order is Annexure 1 at page 14, at page 19. Annexure 1, page 19.
Yes.
And P2's appointment order is Annexure 2 at page 20.
Yes.
Then paragraph 5, your lordship. In the year 2011, the Directorate of Vigilance and Anti-Corruption began an inquiry into appointments under the Department of Health and Family Welfare. 2011. Then by letter dated 14/10/2011.
This inquiry was confined to the appointments in the which department? Health department.
Department of Health and Family Welfare.
Yes.
Then by a letter dated 14/10/2011.
Yes.
Which is Annexure 3 at page 21.
Yes.
The Superintendent of Police, Vigilance and Anti-Corruption requisitioned the original documents of the petitioners. So petitioners in both this case as well as the previous case.
Previous means the other
case. The other case also. So by letter dated 13/11/2011, which is Annexure 4 at page 23, the original appointments orders of the petitioners in both cases were forwarded.
Okay.
Both cases forwarded.
Then thereafter?
They were summoned by the anti-corruption police.
Okay.
They answered the summons. Then subsequently, by a letter dated 34/2000.
Did the petitioners appear?
They appeared.
Okay.
They appeared. Yes. Subsequently, my lord, by a letter dated 34/12.
Yes.
An order was issued to withhold their salaries of the petitioners. So that is Annexure 5 at page 24. And the direction was that it is suspected they were appointed under forged signatures. Therefore, their appointment should be withheld. There were two categories, Your Lordship.
Yes.
The first category was the persons appointed without sanctioned posts. And the second category, persons appointed under suspected forged signatures. So we
Okay.
fell in the second category.
Okay.
The petitioners here, as well as in the other case also. Suspected forged signatures.
Yes.
Then, aggrieved by that order, we filed WPC number 52K 2014 and WPC number 61K 2014. So the petitioners in
52 and 62.
yes, my lord, 52 and 62,
Yes.
and by a common order and dated 18/9/2014, which your lordship will find at page annexure 6, page 29.
Yes.
So this honorable court directed that no adverse order should be passed without giving the petitioners an opportunity of being heard. And inquiry.
This was a final order.
Yes, my lord. And inquiry should be as expeditiously disposed of as possible.
Yes.
Writ petition 52 and 61, my lord. 52K and 61K.
61.
61, my lord. Then this was followed by an order dated 27/4/2015, which is annexure 7 at page 25,
Order by
the Directorate of Health.
an earlier order, you said 29, page 29. Was it 24?
Page 24, my lord.
18/9 was 24.
34 is.
No,
page
no,
24.
18/9, 20,
18/9 is 29.
29.
That is the judgment and order of this honorable.
Then how do you go back to 27/4 then? 2015 at page 25. Is it 35 or 25? Just now I have said the order of 27/4/15.
27. Let me check, your lordship.
It cannot be 25. You cannot go back.
Page 25, yes. Page 25. Page 25 is a continuation, your lordship. Page 25 is a continuation. The actual termination order. No, page 25 is a continuation, your lordship, of
27.
the previous order.
Yes.
The previous order.
Which order?
29 is a continuation of 34/2012. 34/2012, 27/2000. No. Just a minute. No. Dismissal is? No, this is 2015, your lordship.
Yes, 15. So the page should be after 29. How can it be 25 page?
Yes, madam. Yes, madam. A mix up in my.
Or it came
pagination.
before?
Yes, madam.
Okay.
A mix up in my page.
Okay, doesn't matter. 27/4/15, what had happened?
This is the order by which I was dismissed.
Dismissal order.
Yes, this is a dismissal order. Again, the ground was not because the documents were found forged, but on suspicion. On suspicion. At page 35. At page 35. And so I filed the WPC number 157K 2015.
157.
Yes, my lord. 157K 2015.
Yes.
And in this 157K.
This is a common
for both the petitioners.
Okay.
In both the petitions now before your lordship.
Okay.
And by an order dated 25/10/2017.
25/10.
25/10/2017, which is annexure 8 at page 39. The order was set aside and the direction for reinstatement
Yes.
So pursuant to that, your lordship, the order of 22nd, there was another order which was passed first initially, but subsequently that was revised, and the order of 27/8/2018.
27/10.
27/8/2018.
Yes.
Which is annexure 15 at page 78.
Yes.
Can we go? This is the impugn order. Can
Yes,
we go to
yes.
the impugn order?
78.
Yes, page 78. Type copy is at page 79.
Yes, please.
Type copy is page 79.
Yes, reinstated.
Yes. In continuation to this directorate letter dated 4th June 2018, the following undermentioned incumbents were reinstated to their services with effect from 4/6/2018 as per the Honorable High Court order and judgment passed in so and so. They will be paid their arrears from 1/5/2012 to 27/4/2015. However, the incumbents will not be entitled to any back wages with effect from 28/4/2015. That part is all right. Therefore, the period with effect from 28/4/2015 to 3/6/2018 will not be accounted for qualifying service nor for increment. So this is what I am aggrieved with. And this is the case. And because of this break in service, the respondents are also saying, the state respondents are saying that I am not entitled to the MECP because I do not have the qualifying length of service. So that is my case, Your Lordship. Sure. Page 81. 81, 90. And, Your Lordship, one of the petitioners in the earlier round of litigation,
Yes.
that petitioner has been given her entire benefits, including MECP as well as increments. And that example I have shown in Annexure 16 at page 81.
Just a minute. One similarly situated.
Yes, my lord. One similarly situated person,
Yes.
she filed 158K separately. 158K of 2015. They were clubbed together, and by the common judgment and order, the order of reinstatement was passed.
Where is her order?
The same judgment and order, Your Lordship.
No. Her order of
Page 81.
81. No
Page
condition. No condition attached.
No. Her order of reinstatement, I don't have, Your Lordship, but Your Lordship will see from the document Annexure 16.
Yes. Which one? Serial number?
Serial number, the person's named as Namhai. That's serial number 2.
To surveyor.
Yes. Namhai Surveyor. She has been given everything, including the MECP.
Okay. This factual assertion of yours, is it refuted by the
No.
state?
It's all admitted.
This is a factual.
Yes.
Okay.
The only stand taken by the state respondents is there is a specific condition, and I have accepted that condition, which is not the case. And the other ground taken was that I have not challenged this order of 27/8/2018. But when I initially filed the application,
Which you have not
page
challenged?
78,
78.
yes, the order impugned.
Yes. 27/8. 27/8.
Yes, 27/8.
Yes.
But I have actually challenged it.
Okay.
I have actually challenged.
No, you have challenged a part of the order, the condition imposed.
Yes.
You are not aggrieved by your reinstatement.
No.
You cannot be aggrieved by
I
your
can't be aggrieved
reinstatement.
with
But will that preclude you from challenging a condition in the order?
Yes, ma'am.
That is the question.
That is the question.
That is your case.
That is my case.
Are you placing any case law?
Your Lordship, on the principle of DS non, Your Lordship, break in service. Lordship, this is 2007 3 JLT at page 434.
2007
3 JLT at page 434.
GLT 434.
434.
Tapan Mazumdar.
Yes, my lord, by a division bench. So DS non, an order of DS non cannot be passed without disciplinary proceedings. That's the principle, Your Lordship.
DB order.
Yes, my lord.
Which
Your Lordship,
which
the fact-
paragraph? Which paragraph?
Fact had paragraph 3
No, the
and paragraph 7, 8, 7 and 8, Your Lordship.
on hearing the
Paragraph 8, we can go straight to paragraph 3. In view of the facts and circumstances, we have the considered view that the period from 16/3/95 to 28/12/95, which was declared as DS non by the Director of School Education and also upheld by the learned single judge, cannot sustain in law, and therefore the order dated 12/6 passed by the learned single judge in the.
No, where is the, this is the holding, where is the discussion?
That paragraph 7.
7.
Yes, upon hearing the learned counsel for parties, we have the considered view that before declaring the period of absence of the appellant as yes known, a disciplinary proceeding has to be conducted in the facts and circumstances, more so when allegations of break in service are being refuted by the appellant. So in terms of the rules, Your Lordship, loss of increment, break in service, only by way, if there is a punishment which can be imposed only by way of a disciplinary proceeding, not otherwise.
The DP was held so far your appointment was concerned.
Yes, ma'am.
Thereafter, when the order of reinstatement by the High Court was given,
Yes, ma'am.
there was no further proceeding.
No further proceeding.
In fact, there could not have been a scope of further proceeding after interference of the High Court. The interference was primarily on what basis? By the High Court?
That the suspected forged signatures, not
No,
actually a
that,
finding.
that was the ground for the
Yes.
impugned action. The interference by the High Court.
On that point, Your Lordship,
No.
you
You have not got to us. Was there any procedural failure not to hold any inquiry, or was the interference, was it in merits of the case?
Lordship, it was not sent into the forensic expert.
That means on merits of the case.
on the merits, my lord, on the merits.
But you had followed the procedure to hold an inquiry.
Lordship, inquiry was followed.
Inquiry in the sense only examination of the documents, nothing more. Nothing more.
That was also not a full-fledged
Not
inquiry.
a full-fledged inquiry.
You were not given any opportunity of
Right.
cross-examination. Were there any departmental witnesses?
No, my lord. In fact, the learned single judge also allowed the state respondents to go ahead with the proceedings if they so desire. They did not. They chose not to do so.
Okay, they instead passed this order
Yes,
of
they-
reinstatement. However, this condition has been attached, which you are aggrieved.
Yes, madam.
Okay. Yes. Anything else, Mr. Jones?
That's it, madam. That's it.
And the other one?
Same. They are the writ petitioners in the combined writ petition, Your Lordship.
No, there are 11 numbers. They work as what?
That, Your Lordship.
And the impugned order is the same?
Same. The impugned order is the same.
Okay, I'll just request you to give a list of the petitioners in the other case
Your Lordship, I have
with
mentioned
their
everything in the first
dates of appointment and the what post they were
Very well, my lord.
inducted. Okay, we're dictating the judgment.
Very well, my lord.
Please have your seat. An order dated 27/8/2018
Yes, madam.
passed by the Principal Director, Directorate of Health and Family Welfare, Nagaland, by which a condition has been attached pursuant to the order of reinstatement of the petitioners is the subject matter of challenge in this application filed under Article 226 of the Constitution of India. Full stop there. The facts stated in brief are that the petitioners in these two cases were appointed in the department on various dates, either as surveillance worker or female attendant,
Different posts, Your Lordship.
in different posts, first up, to different posts, which are given in the chart below. Please give the name of the petitioner, the petition number, and the date of appointment and this thing. Let's make a chart.
Very well, I'll do that, madam.
Okay. It is the case of the petitioners that pursuant to such appointments, they were discharging their duties to the best of their abilities. Full stop. However, in the year 2011, there was an inquiry on the aspect of appointment in the Health and Family Welfare Department. And in that regard, the Superintendent of Police, Vigilance had issued a communication dated 14/10/2011 requisitioning the documents pertaining to such appointments. Full stop. It is averred that all the original orders of appointments were duly furnished to the authorities and were verified. Full stop. It is also averred that the petitioners had appeared before the authorities and had made their statements. Full stop. Nevertheless, an order was passed on 30/4/2012 to withhold the salaries of the petitioners. It has been clarified that there were two categories involving such persons. The first category was where the appointment were suspected to be fraud, and the other category was such appointments which were made beyond the sanctioned strength. Full stop. The petitioners belong to the first category. Full stop. The aforesaid order dated 30/4/2012 was the subject matter of challenge in two writ petitions, namely WPC 52K of 2014 and WPC 61K of 2014. Full stop. Both the said two writ petitions were taken up for an analogous hearing and were disposed of by this court vide an order dated 18/9/2014, whereby it was directed that no adverse order was to be passed without giving the petitioners an opportunity of hearing and by holding an inquiry. After the aforesaid direction, some inquiry was held, which culminated in an order dated 27/4/2015, whereby the petitioners were dismissed from service. Full stop. The ground cited in the aforesaid orders of dismissal was that the appointments was on the ground of suspicion that the appointments was fraudulently made. Full stop. The said order of dismissal was the subject matter of challenge in a writ petition instituted by the petitioners registered as WPC 157 (K) of 2015. Full stop. The said writ petition was, however, allowed by this court vide order dated 25/10/2017, whereby the dismissal orders were interfered with and accordingly set aside, with a further direction for reinstatement of the petitioners. Full stop. Consequently, an order dated 4/6/2018 was passed reinstating the petitioners. Full stop. Immediately thereafter, no, not 4. What is yes? Immediately thereafter, 4/6. Yes, 4. Immediately now. Thereafter, the impugned order has been passed on 27/8/2019, whereby a condition has been attached, whereby two conditions have been attached, namely that the incumbents would not be entitled to any back wages with effect from 28/4/2015, and that for the period 28/4/2015 to Tier 2, 3/6/2018, the incumbents will not be eligible for and further that the period would not be counted, would not be counted for qualifying service or for increment. Full stop. It is the second condition which is the specific subject matter of challenge. in these two writ petitions. Full stop. Para. I have heard Sri so learned counsel for the petitioners. Full stop. I have also heard Sri so learned state counsel. State counsel, who has also informed that affidavit in opposition has been filed. Para. Sri so learned counsel for the petitioners has submitted that the order dated 25/10/2017 passed by this court in WPC 157K of 2015 did not attach any condition and had simply set aside the order of dismissal, full stop. Though there was an observation giving liberty to the respondent authorities to cause an inquiry, comma, such inquiry was not done, and the impugned condition has been attached, by which the petitioners would suffer immense prejudice in their service. Full stop. It is submitted that if there is a break in service for the period from 28/4/2015 to 3/6/2018, comma, the petitioners would be deprived of the benefits of MSCP, comma, seniority, comma, fitment in the proper scale, and also promotion, and also timely promotion. Full stop. The learned council has fairly submitted that so far as the first condition is concerned, namely not being entitled to back wages with effect from 28/4/2015, comma, the petitioners have not raised any serious grievance, mainly on the principle of no work, no pay. Full stop. However, the impugned condition of not counting the period from 28/4/15 to 3/6/18 for qualifying service or for increment would be highly prejudicial, which requires interference by this court. Full stop. The learned council has submitted that the benefits in service are legal rights of an employee, which are required to be considered in a proper perspective. Full stop. Since this court had interfered with the order of dismissal by the order dated 25/10/2017, comma, the respondent authorities would not be, and it would not be proper or correct on the part of the respondent authorities to take any action which is adverse to the interest of the petitioners who have been discharging their duties in the post appointed to the best of their abilities. Full stop. Para. The learned council has also tried to make out a case of discrimination and violation of Article 14 of the Constitution of India by citing that a similarly situated incumbent, namely so-and-so, Namhai, who was appointed as a surveyor and was also one of the petitioners in the initial case, had filed a separate writ petition being WPC 158K of 2015, and all benefits were given to the said incumbent. Full stop. It is submitted that the petitioners are similarly placed, and therefore there cannot be any discriminatory treatment so far the petitioners are concerned. Full stop. Reliance has been placed in the case of A division bench of this honorable court reported in 2007, 3 GLT 438, named Bimal Devnath, wherein it has been laid down that
434, my lord. Tapan Mazumdar.
yes, yes,
434.
yes, 434. Where it has been laid down, where is it? No. Oh, sorry, not this one. Oh, yeah. 2007 3 GLT 434, wherein it has been laid down that before declaring a period of absence as dies non, a disciplinary proceeding has to be conducted full stop. For any reference, the relevant observations are extracted here in below para 7. Para. Sri so Learned State Council has, however, opposed the writ petition, has however strenuously opposed the writ petition, full stop. He has submitted that though this court had interfered with the dismissal order, vide the order dated 25/10/2017, there were no specific conditions imposed that the reinstatement has to be done without any further condition, full stop. He has submitted that the reinstatement was initially done vide order dated 4/6/2018, and the present order dated 27/8/2018, which is the subject matter of challenge, was done after taking into consideration the aspect that for the said period, no duties were performed by the petitioners, full stop. He has also submitted that all the petitioners had accepted the order dated 27/8/2018, which would mean that conditions attached thereto were also accepted, full stop. He therefore raises the aspect that the present petition is barred by the doctrine of estoppel and waiver, full stop. He has otherwise submitted that the impugned decision is based on the consideration that the petitioners had not, as a matter of fact, discharged their duties for the period in question, and the interest and the interest of the state as well as public interest were taken into consideration before passing the said order, full stop. He accordingly submits that the order dated 27/8/2018, that the condition, that the impugned condition is not required to be interfered with, full stop. Anything else?
Lordship, Lordship, may kindly come to page 36, Lordship. This is
Yes,
annexed to your deed, Lordship.
yes.
The Principal Directorate of Health and Family Welfare,
36.
Lord.
Yes, what is there?
36, annexed to your deed, Lordship.
Hmm.
This letter has been forwarded to the Directorate Deputy Inspector General of Police to conduct a fresh inquiry, Lordship. Page 36 of the affidavit in opposition.
Where is it? To fresh inquiry? It's only marked. For information, please.
36 of the affidavit in opposition, Your Lordship.
Of the affidavit of opposition.
Affidavit in opposition.
What is the internal page? Anything?
Affidavit in opposition of WPC 50 of 2021, Lordship.
36.
Page 36, annexed to deed.
Yes.
This letter has been forwarded by Principal Director to the Directorate of Deputy Inspector General of Police.
A letter written in the year 2018, Your Lordship. Page 36.
Affidavit in opposition.
Lordship. WPC in
of the respondents 1, 2, and 3 in WPC number 50.
50 of 2021.
Yes, 1, 2, and 3. Yes, I have now to page 30.
36. We'll conduct for a fresh.
Just a minute, just a minute. There is no 36 ways to pay. It ends at 33. Then the 33, last page is 33.
There must be a
Then-
second affidavit, Your Lordship.
Lordship, if Lordship may kindly come to page WPC 23 of 2021.
Not in 50.
This is there in 50 also.
Is there in 50 also?
50 also.
Yes.
50, see.
There was a second affidavit which was filed after the amended petition, Your Lordship.
Okay, yes, you're correct. 36.
36.
Is it, what is the date? There is no date, June 28, date 2018,
Lordship,
to the director, written by the principal director.
Lordship.
This
is
then, yes.
86
Okay.
2018.
But nothing culminated from here.
No. Till that.
He has also drawn the,
Your
yes.
Lordship, the impugn order was passed after this.
Okay. Yes, yes. He has also drawn the attention of this court to a communication of, what is the date?
86.
To a communication dated 8/6/2018, issued by the principal director of the department to the Deputy Inspector General of Police,
Lordship.
Vigilance and Anti-Corruption, Nagaland, to conduct a fresh inquiry. Full stop. However, it appears that no such inquiry was made, and in the meantime, the impugned order dated 27/8/2018 has been issued. Where the rival submissions have been duly considered, and the materials placed before this court, including the affidavit in opposition, have been carefully perused. Para? It transpires that the appointments of the petitioners made in the years 2007/2008 were the subject matter of some suspicion for which the department had taken action initially by having a preliminary inquiry done on the appointments, followed by an order dated 30/4/2012 to withhold the salaries. Full stop. As mentioned above, there were two categories of such appointments. The first category, where the petitioners are connected, is that the appointment orders were fraudulently issued. And the second category was that the appointment orders were made for post beyond the sanctioned strength. Full stop. Be that as it may, the order dated 30/4/2012 was the subject matter of challenge in WPC 52K 2014 and 61K 2014, wherein this court had passed an order dated 18/9/2014, directing that no adverse orders be passed without holding any inquiry. Full stop. It appears that some kind of an inquiry was held, leading to passing of the order of dismissal on 27/4/2015. Full stop. A perusal of the order of dismissal would, however, reveal that such action was then taken more on the basis of a suspicion. Full stop. Be that as it may, the said dismissal order was the subject matter of challenge in WPC 157 within bracket K of 2015, and this court had interfered with the same by setting aside
This is dismissal order. Void the judgment dated 25 colony 25/10/17 colony. Void the judgment dated 25/10/2017. Full stop. There was also a direction for reinstatement with an observation that the respondents would be at liberty to hold an inquiry. Full stop. As noted above, comma, there was a request by the department to the vigilance cell to hold an inquiry, which, however, does not appear to have been done. And in the meantime, the order of reinstatement was issued. Full stop. The said order of reinstatement was followed by the order dated 27/8/2018, whereby the condition whereby the impugned condition was attached. Full stop. The question therefore arises is as to whether such a condition can be lawfully imposed in the following the order of reinstatement. Full stop. Para. The dismissal order was set aside by this court on 25/10/2017 with a liberty to hold a fresh inquiry. Full stop. It, however, appears that no such fresh inquiry was held, and in spite of that, the impugned condition has been imposed. Full stop. This court is unable to accept the submission made on behalf of the department that accepting the reinstatement order dated 27/8/2018 would preclude the incumbent to challenge the condition imposed to the same. Full stop. The interest of a dismissed employee would be to get reinstatement, which would be foremost, and the same cannot mean that any conditions imposed in the said order of reinstatement cannot be challenged. Full stop. Therefore, there will be no application of the doctrine of estoppel or waiver. Full stop. This court has noted the submission advanced on behalf of the petitioners that so far as the condition of back wages is concerned, there is no serious challenge. Full stop. The challenge is only with regard to the condition by which the period from 28/4/2015 to 3/6/2018 would not be counted for qualifying service or for increment. Full stop. The aspect of continuity in service is an important facet of the service rendered by an employee. Full stop. Such continuity would not only be of not only of benefit for an employee serving the department, but is also a legal right. And any tampering with such rights would have to be preceded by a duly conducted inquiry, which does not appear to have been done in the instant case. Full stop. This court is also has also taken into consideration that a similarly situated incumbent who had filed a separate writ petition WPC 158K of 2015 has been given all benefits and without any condition attached. Full stop. There is no refutal of facts by the state government in the affidavit in this regard. Full stop. Therefore, a case of discrimination is also apparent on the face of it. Para. Considering the facts and circumstances, comma, this court is of the opinion that a case of interference is made out. Full stop. Accordingly, the impugned condition of not counting the period from 28/4/2015 to 3/6/2018 for qualifying service or for increment is set aside. full stop. The petitioners would accordingly be entitled to have continuity in their service for the aforesaid period, and accordingly to get all consequential benefits of the same. Full stop. Writ petitions, both the writ petition accordingly stands allowed in the manner indicated above.
Much obliged, Malad.
Please give that list. Okay.
For hearing, item number 16.
Yes,
Wait, please, Lordship.
you're for the petitioner.
Yes, Lordship, I'm for the petitioner, Lordship.
As for the railways,
Railways, the Lordship, Mr. Harish Gupta, CGC from Gauhati is representing.
We supposed to, but I not travel.
okay, doesn't matter.
I can do it on VCOs. Yes.
You're not very clear. We can see you, but we cannot hear you properly. What is it? What is your instruction?
My lord, I'm for the state, my lord. I'm ready, my lord.
He's for a CGC.
Yes, my
Yes, Mr. Gupta? Mr. Gupta? You're not audible.
For the railways, my lord.
Yes. So we go ahead with the hearing.
My lord, my lord. My lord.
Yes.
Lordship, this is matters for payment of compensation, Lordship. The railways, they have acquired, they're in possession of my land for last more than 4 decades, Lordship.
It's your land.
Yes, Lordship. And the state, they have also admitted that. And it is also an admission of the state that land compensation has not been paid at any point of time, Lordship. That is the case, Lordship. Also, in the state of Nagaland, we have an enactment, Lordship.
Yes, which one?
Nagaland Land Requisition and Acquisition Act 1965, Lordship.
Yes, can we have that book?
Lordship, before coming to that, if I may be allowed to take your Lordship to the facts, Lordship.
Yes.
May I take your Lordship to page number 21, Lordship?
21.
Yes, Lordship, page 21 of the writ petition, Lordship.
Yes.
Lordship, this is a communication in the year 1986, Lordship. This is dated 6/1/1986, Lordship.
Yes.
May I read the Lordship?
Yes.
This is addressed to the Deputy Commissioner, Mohokchong, Nagaland. So the DC of the concern.
This will make a lot of sound over it. No, exhaust fan. It makes sounds. No. Does it makes a lot of sound over it? Just put it. Let's see. Or you can open some windows also. Open some windows. Stuff is slightly. But yes. Open some windows. Okay. Yes.
May I read it, Lordship?
Yes.
Subject construction of a railway siding for the NPPC at Tuli and Nagaland, land cost and compensation regarding, Lordship. That is the subject, Lordship. It is proposed to construct a private railway siding for the Nagaland Paper Company from the proposed Tuli station. Tuli is placed.
No.
It's a town that falls under Mohokchong district, Lordship.
Okay.
And it is the neighboring to Amguri that falls in the Sibsagar district under Assam, Lordship. near the 15 kilometer of AM road, that is Amguri Road, Lordship, to the NPPC premises of Tuli. The alignment will be close to the AM road and the land is falling within so-and-so village. That is the village. And the petitioner belongs to this village, Lordship.
Yes.
To prepare an estimate for the above work, a survey has been conducted, The value of land along with the compensation rate, if any is required to keep necessary provision in the estimate. Will you therefore kindly finish the rate of land compensation, etc. for a strip of lane about 300 meter wide, right from the 15 to 20th kilometer of AM road. So it is within a stretch of 5 kilometers, Lordship. The requirement is around 300-meter wide. Within this 5 kilometers stretch, the wide required is 300 meters.
Yes.
Lordship, by this document itself, this is the initial document. This document itself shows that none of the authorities had the intention to acquire the land in terms of the existing statutory rules or provisions, Lordship. Now, what has happened, Lordship? Next, the page 22, if I may take
Yes.
Lordship to the next page, Lordship.
Yes, please.
So this is a letter written by the SDO Civil, Mohokchung District, Nagaland, to the Executive Engineer, NF Railways. May I request you to kindly report the office of the undersigned on so and so to determine compensation of land, standing corps, etc. likely to be damaged during construction of railway within Wamakan village jurisdiction. This is the village, petitioner's village. In this connection, you may be direct some other officials who are acquainted with above so as to represent on your behalf. Landowners of Wamakan village are also already requested to be present on the date and time. So an intention, and this is a communication to the railways to determine the compensation.
Yes.
Before acquiring the land.
Yes.
Now, Lordship, if I may be allowed to take a Lordship to page number 26. They have clearly stated for compensation of land and for the major's, Lordship. Now, page 26. This is the letter written to the DC Mohokchung by the SDO. I have the honor to forward here with the minutes of discussion held on so-and-so at so-and-so regarding the assessment of standing costs and valuable trees likely to be damaged during the construction of railway line from Amkuri to Tuli for favor of your information. So certain assessment was done on that particular day in the year 1986. Accordingly, Lordship, I agreed that I was paid an amount of rupees 11,950, Lordship, in the year 1992 for the damage compensation, Lordship.
Yes.
An assessment was done. Lordship, you want to find the actual payment receipt at page number 42, Lordship. Page number 42. 42 is the type copy of the actual payment receipt, and 41 is the original copy of the payment receipt, Lordship.
Yes.
Received an amount of rupees 11,950 from the railway department through the office of so-and-so, against the damage of corpse while constructing so-and-so. So it is solely for damage compensation, Lordship. 11,950, Lordship. Now page number 30, Lordship. Page 30, Lordship. The
Yes.
type copy, Lordship, will find at page number 31. The railway authorities are relying on this document, Lordship. This is the letter written to the Deputy Commissioner by the Railways, Lordship. It was on 27th of August, 1987. Sir, in inviting reference to your letter on the subject cited above, I have the honor to forward here with a detailed assessment of land compensation and standing costs, the measures for construction of railway line between Amkuri to Tuli, the amount of which is work out at rupees 1,57,000 only will be required to be paid to the landowners of concerned village, including the cost of standing costs to match. So it is for the land compensation as well as the damage compensation, Lordship. An amount of rupees 1,57,000. And this is a communication written by the DC
Yes.
to the railway authorities, Lordship. Nowhere it has stated that The land was acquired in terms of the provision of any statutory law, Lordship. Nowhere it has been mentioned, Lordship. It is just a rough assessment of the Deputy Commissioner, the concerned Deputy Commissioner, Lordship. Now, page number 36, Lordship, page number 36. Page number 36. The typed copy, Lordship, will find page number 37. May I read the Lordship? If your Lordship got it. This is later dated 16 April
Mr.
1991.
Counsel, this proceeding was in the year 1986-87.
Lordship.
How do you now say that 2013 can be invoked?
Lordship,
This acquisition proceeding was over a long time back.
Lordship. At that point of time, Lordship, the Land Acquisition Act 1894, as well as the Nagaland Land Acquisition Act 1965 was still also in field, still is, Lordship, in existence.
So, but the process, the exercise was completed long time back. You may have a case for an assessment under the statute holding the field.
Lordship.
Now be instituting this writ petition in the year 2022.
Lordship.
Can you say that I want the 13 Act to be followed? Was the 13 Act in existence at the time?
No, Lordship.
It was
no,
not
Lordship.
even in contemplation.
Yes, Lordship.
You can pray for a fair assessment, fair
Yes, Lordship.
compensation.
Yes, Lordship.
But it is not necessarily to be under the 13 Act. It cannot be.
Lordship.
If it was a continuing proceeding,
Lordship.
like for proceedings where there were litigations and in the meantime 13 has come, 13 itself has made a provision
Yes, Lordship.
that it is the 13 Act which will override all the aspect of compensation.
Lordship.
But this matter was brought to an end
Lordship,
long time back.
My very limited prayer is to acquire in terms of the Act, Lordship, State Act of 1965,
But
Lordship.
when did you come to the court?
Lordship, I have also made certain statements in the affidavit, Lordship. Lordship, may kindly appreciate 2022, Lordship. There's a judgment of the Honorable Apex Court that if there is a delay, Lordship, but if a right has been infringed, the question of delay in leisures does not arise, Lordship.
No. We are in a court. We are a court of equity.
Lordship.
Equity court, the question of laches will definitely come. You cannot sleep over your rights.
Lordship, the judgment that I'll rely upon, Lordship, it squarely covers my case.
Let us see.
In fact, Lordship, that case is for the state of Himachal Pradesh. That took over the land in the year 1970s, Lordship. Mine is 1980s. Lordship, what has happened, direction was given to acquire in terms of the... Yes,
let us see the Himachal case.
2022-7 SCC 508, Lordship.
You can take this back.
2022-7 SCC 508, Lordship. It's a short judgment, Lordship. May I read from paragraph 2, Lordship? Paragraph 2 starts with the facts, Lordship. May I read, Lordship?
Just a minute.
Lordship.
Yes, please read paragraph what to, please read the facts.
Lordship. Paragraph 2, Lordship. Mr. So-and-so and so-and-so claim to be owners of land situated at so-and-so of Himachal Pradesh. The respondent state utilized the subject land and adjoining lands for the construction of so-and-so road in the year 1972, but allegedly no land acquisition proceedings were initiated, no compensation given to the appellants or owners of the adjoining land. Pursuant to a judgment by Himachal Pradesh High Court directing the state to initiate land acquisition proceedings, a notification under Section so-and-so of Land Acquisition Act 1894 was issued in the year 2001, Lord. And the award was passed on 2012-2001, fixing compensation at rupees so-and-so. Proceedings under Section 18 of the Act for enhancement of compensation were initiated by 10 neighboring landowners whose lands were similarly utilized for the construction of the same road, and an award dated so-and-so was passed by the reference court in their favor. It was held that the reference petitioners were entitled to enhanced compensation of rupees so-and-so per biga, solicitation of 30% on the market value of the land, additional compensation of 12% under Section 23(1)(a) of the Act till the date of making of the award by the collector, and under Section 28, interest of 9% per annum from so-and-so for a period of 1 year, and thereafter 15% till the date of payment. In the year 2009, the High Court dismissed the appeal against this order by those claimants who were seeking statutory interest from the date of taking possession. Similarly, situated landowners filed writ proceedings before the High Court. A writ petition filed by one so-and-so from the adjoining village was allowed by the High Court with the direction to acquire lands of the writ petitioners under the Act, with consequential benefits. Subsequently, other similarly situated owners also received the benefit of these directions. This led the appellants to file a writ petition before the High Court in the year 2011, seeking compensation for the subject land or initiation of acquisition proceedings under the Act. Relying on a full bench decision of so-and-so, it was held in the impugned judgment that the matter involved disputed questions of law and fact for determination of the starting point of limitation, which could not be adjudicated in writ proceedings. The writ petition was disposed of with the liberty to file a civil suit in accordance with law. Aggrieved, the appellants have approached this court through this appeals. This is a very important, Lordship. From paragraph number 6 till 12, these are the contentions, Lordship. However, the state has also raised the contention of disputed question of facts, which was adjudicated by the Honorable Apex Court, and certain observations were made, Lordship. The relevant paragraph starts from paragraph 14, Lordship. Paragraph 14, Lordship. Page number 516. May I read, Lordship? It is the cardinal principle of rule of law that nobody can be deprived of liberty or property without due process or authorization of law. The recognition of this dates back to the 1700, to the decision of the King's Bench in so-and-so, and by this court in the case of so-and-so. Further, in several judgments, this court has repeatedly held that rather than enjoying a wider bandwidth of lenience, the state often has a higher responsibility in demonstrating that it has acted within the confines of legality, and therefore not tarnish the basic principle of rule of law. When it comes to the subject of private property, this court has upheld the high threshold of legality that must be met to dispossess an individual of their property, and even more so when done by the state. In the case of so-and-so, this court rejected the contention that the petitioners in the case were trespassers and could not be removed by an executive order, and instead concluded that the executive action taken by the state and its officers was disruptive of the basic principle of rule of law. 16. Given the important protection extended to an individual, their private property embodied earlier in Article 31 and now as a constitutional right in Article 300A, and high threshold the state must meet while acquiring land, the question remains, can the state, merely on the ground of delay in leisures, evade its legal responsibility towards those from whom private property has been expropriated? In these facts and circumstances, we find this conclusion to be unacceptable and warranting intervention on the grounds of equity and fairness. 18. There is a wealth of precedents on delay in lectures which conclude either way, as contended by both sides in the present dispute. However, the specific factual matrix compels this court to weigh in favor of the appellant landowners.
Can you ask to bring my iPad? Yes.
The state cannot shield itself behind the ground of delay in lectures in such a situation. There cannot be a limitation to doing justice. This is very important, Lordship. There cannot be a limitation to doing justice. This court in much earlier cases, which is reported in so and so, now the doctrine of lectures, courts of equity is not an arbitrary or technical doctrine, where it would be particularly unjust to give a remedy either because the party has, by his conduct, done with which might fairly be regarded as equivalent to a waiver of it, or whereby his conduct and neglect he has, though perhaps not waiving that remedy, yet put the party in a situation in which it would be not be reasonable to place him if the remedy were afterwards to be asserted in either of these cases. Lapse of time and delay are most material, but in every case, if an argument against relief, which otherwise would be just, is founded upon mere delay, that delay, of course, not amounting to a bar by any statute of limitations, the validity of that defense must be tried upon principles sustainably equitable. Those circumstances always important in such cases are the length of delay and nature of the acts done during the interval, which might affect either party and process so and so. Relevant paragraphs are 18, 20.
Just give us a minute.
Lordship.
Okay. Yes, Mr. Gupta, what do you say? I will come back to you.
Lordship.
Yes, Mr. Gupta.
In fact, my lord, what has happened in this case, my lord, this petition is, my lord, completely hit by delay in latches, my lord. This land acquisition took place in the year 1986, my lord, and in the year 1990, the construction of the Amguri Tuli siding was completed. In fact, my lord, there are communications on record which clearly shows that, my lord, the land acquisition compensation was assessed and was duly paid. If my lord takes page 40 of the writ petition.
40.
That is the document which I have relied. Thank you, Your Lordship. Payment of 11,950.
Yes, 40. Yeah. Now, what about the decision of Sukh that which Learned Council has referred to? That case.
Since the compensation has already been assessed and paid, there is no question of delay and latches. My learned friend, the petitioner, in fact, has not come with clean hands, my lord, before the Honorable Court. First of all, my lord, they are coming after 28 years before the Honorable Court seeking compensation. At the best, my lord, they could have made a reference under Section 18 for seeking enhancement of compensation, which is also time barred. And on the other hand, the claim which they are making that they have not been paid compensation, that is, my lord, categorically denied by us by filing an affidavit, and wherein we have stated that the amount of land compensation was duly assessed and was paid, in addition to the, my lord, compensation for the standing crops. And, my lord, so the claim of the petitioner that they have not been paid land acquisition compensation is, my lord, categorically denied by us, my lord. in the affidavit which we have filed. And my lord, in fact, there are communications on record which shows that the deputy commissioner
Gupta,
has,
if-
yes,
if you are contending that they had the remedy under section 18 to seek for a reference, the compensation,
yes.
the communications connected to the compensation does not really even mention that the Act of 1894 has been taken into consideration. Where do they file the reference? Under which act?
My lord, but if my lord will take page 31, that was the compensation which was assessed by the deputy commissioner.
31.
There is a page 31, my lord.
Now 31 we have seen. 31 is under which act?
Lord, that is, my lord, since the railway is also not having the record, my lord, it's a 34-year-old case.
Understood.
We tried to trace the record. Even the state government, my lord, they have not come with any clear stand
No,
regarding.
Gupta, but you may be correct in contending the aspect of delay, the aspect
No.
of using a reference. But we need to know exactly that under which act this compensation was assessed. We may accept your submission that the assessed compensation has been accepted by them. That's a different matter. But the assessment was done under which act, which statute? There is a statute of 1965 of Nagaland that does not find.
For the state government to clarify, my lord, for the railways, there is a clearly communication on record, my lord, by which we were directed to pay a certain assessed amount of compensation. That we have paid, my lord.
Yes, Mr. State Council.
Yes, my lord.
Compensation was under which act?
My lord, in that letter, that act has not been mentioned under which act.
But your
assessment.
instructions.
My lord, in the instruction it says that compensation has not been paid. My lord, in my affidavit, your lordship.
Compensation has not been paid.
Yes, my lord. Your lordship may kindly see the page.
Compensation has not been paid, Mr. Gupta.
My lord,
That would be a contradictory, my lord, statement because their own communication shows they have assessed the compensation. Page 31.
The aspect of assessment, the aspect of making the payment of the assessed amount. Has it been done?
Yes, my lord, it was done, my lord. There is a communication at page, my lord, page 40.
40. We have just
Because only after the payment of compensation, my lord, we can acquire the land. Without paying, the railways will not be allowed to take possession of the land.
Now we
Page
have
40, my lord, is the.
We have a receipt of 1,000 something, but we don't have a receipt of this 157. 40.
Yes, my lord. Page 40, if I may read, my lord, this is a communication addressed by the Deputy Chief Engineer to the Deputy Commissioner Mokokchung.
It was paid to your Deputy Commissioner.
no, my lord, your lordship may kindly see the affidavit filed by the state, my lord. Your lordship may kindly see paragraph 5.
For a 5.
Yes, my lord.
Affidavit by the
State.
state.
2, 3, and 4. 2, 3, 4, and 8.
By Polan John. Polan John. Polan John is the deponent.
Yes.
Paragraph?
Paragraph 5. May I read, my lord?
Yes.
That with regard to the statement made in paragraph 27 of the writ petition is not denied. However, the answering deponent humbly begged to state that by the letter dated 0109/2022, the then ADC duly has conveyed to the Deputy Commissioner Mokokchung in regard to the joint survey for development of goods train service from Amkuri to Tuli, wherein it has been verified and ascertained that land compensation was not paid to the petitioner, either by the railways or the state government. State government, yes. The Mohokchung district administration had also written to the railways that land compensation or government grade 4 appointments should be given by the railway as per conventions. In this connection, it was also opined that in principle of uniformity, compensation to the petitioner should be paid by the railway, which is in line with the recent acquisition of land by the railways Dimapur Kohima railway line, where land compensation to the landowners had already been paid by the railways.
How do you respond to this letter at page 40? Place 40.
My lord, as per this paragraph, it says that joint survey was conducted.
No, in page 40,
Yes.
in the communication, there is a clear statement that 1,57,000
Yes.
was paid to the deputy commissioner by the railways. Because railways are not in a position to pay directly to the land affected person.
Yes, my lord.
It will go through the office of the deputy commissioner.
Yes.
They have made a statement in this communication at page 40 that 1,57,000 was indeed paid to the deputy commissioner. What is your response to that?
My lord, since the railway they are saying that they have already paid. If they have already paid, then the payment receipt should be there, my lord.
No,
Only
they have-
this is the communication letter,
No,
my
they
lord.
have paid to you.
Yes, that's what I'm saying, my lord.
Yes.
If the state government has received,
Yes.
there should be payment receipt, isn't it, my lord?
Can you get
This is
some
the letter,
instruction,
my
Mr.
lord. This is
Gupta?
the letter only.
Can Mr. Gupta? Can you get some
My lord,
supporting document?
Yes, my lord.
my lord, we have checked all the records, my lord. It's a very old case, my lord. And we have stated in the affidavit, my lord, that because normally the records are kept for certain period, my lord, in the railways also. It's a 34-year-old case, my lord.
But if the state is denying that,
We have all,
see, if you have paid, we cannot burden you. It will be a different matter if we agree with the learned council to go on the other aspect of the argument that apply the Act of 2013. But if we do not, then at least we have to ensure that whatever you have assessed has indeed fallen in their hands, which does not appear to have been done because state government is denying receipt of any payment. We need to come to the affidavit they have stated.
my lord, since it is a court of equity, my lord, prima facie, they have to satisfy that they have not been paid compensation. There are communications on record, my lord, which clearly shows that land acquisition compensation was asset, even additional compensation for crop was also paid.
Gupta, the problem has arisen because the deputy commissioner's affidavit states that no amount has been received by their office. We are fully aware of the aspect of equity court delay; those will be taken care of. But if the assessed compensation has been denied to have been received by the deputy commissioner's office, we have to first address that question.
Yes.
My lord, the specific stand to that annexure, page 40 letter, that is not there, my lord. This is a letter of 2022, which they have been sent, my lord. Let them file an affidavit, my lord.
You know, it has stated
Clarify.
the respondent numbers 2, 3, and 4. 2, 3, 4 in the affidavit has stated in paragraph 5 directly. Have you got a copy of this? You must have got a copy. Have you got a
They have mentioned communication of, my lord, 1/9/2022.
Mr. Gupta, 1/9/2022 and towards the second part, verified and ascertained that land compensation was not paid to the petitioner either by the railways or the state government.
My lord, here if my lord reads the entire paragraph, my lord, like this affidavit is committee with facts what has happened, because in subsequent line, my lord, it is stated that district administration has also written to the railways that land compensation or government grade 4 appointment should be given by the railways as per convention. There is no question of giving grade 4 appointment. The background facts.
That is not the subject matter of challenge.
It seems, my lord, it seems the deponent is not clear about the fact that there was a communication in year 1992 wherein, my lord, the compensation was paid.
May I take lordship only to two documents, lordship, in my writ petition, lordship. Page number 45. Just two documents, lordship. Page number 45.
Sorry, my lord, lost the connection.
45.
45, Lordship, yes, Lordship. In the read petition.
Yes.
This is a letter written by the ADC to Deputy Commissioner Mohokchung, Lordship.
Yes.
It's dated 31st January 2003. Kindly refer to your letter number so and so. I'm to inform you that I have personally verified the land donated by Shri so and so, that is the petitioner, where 12 number of staff quarters and railway platform are constructed by the concerned department. The donated land is measuring approximately 8 acres. As per this office record, no compensation has been given to the landowner by the railway department nor by the state government, Lord. No, so and so. This may not be relevant. But the first and the second, Lordship, the area of land occupied by the railways, and the second, no record to show that it's
No, if there is the aspect of receipt of this 1,57,000 is not clear, then we may give a direction to the railways to release this money to the state government and consequential payment to you. Because that which was assessed has to be given to you.
And Lordship, if any payment has to be made, it has to be as per the present market value, Lordship. Because
it cannot be present market value.
Lordship, there's a judgment, Lordship.
Present market value, liquid acquisition. What are you saying? Acquisition was made in 19 something.
Lordship, the Supreme Court clearly says at least the 5 years. Within the 5 years, Lordship.
That is not the law.
That is the clear direction.
No, that is not the law. Acquisition proceeding cannot be, if the acquisition proceeding ultimately culminates after 10 years, will you get the price after 10 years? That is why the solicium is there, interest part is there. It is for that purpose.
If all this can be taken care of, Lordship.
This can be taken
But my simple, Lordship,
it's
very
not the
limited
present
prayer
market
before
value,
this
the
unlawful
market
quarters.
value which existed at the time of acquisition. That is the law. There is no second opinion. You may be entitled to solicium, you may be entitled to interest for delayed payment. Those are different laws.
If those are taken care of.
Yes, first we need to take care, we need to ascertain whether 1,57,000 was in fact paid to the Deputy Commissioner and thereafter to the petitioner. Petitioner has denied, Deputy Commissioner has denied in the affidavit. Railways, your affidavit, have you stated you have paid? Mr. Gupta?
Yes, my lord. Yes, my lord. It has been paid. We have stated it has been paid.
Where-
But
where-
in fact, the deputy commissioner should have, my lord, found with at least that finding that 157 was assessed. Even that finding, that fact is also not stated by the
Where is
state
your
authorities. My lord.
affidavit that they have paid?
Yeah, paragraph, my lord, 5. My lord, from the bottom, if my lord, in the letter, my lord, paragraph 5, last paragraph, my lord, second last line
Yes.
starts from there, my lord. In the letter bearing number dated 18/2/1988 by the Additional Deputy Commissioner Mohokchung, stated that the railway has already paid rupees 1,57,000, and further during the distribution of the amount, there was a representation and the railway had to pay another 15,950 against crop compensation. And further, the railway has agreed to pay and sent a check of rupees 153,675. It was further stated that although, as per your letter of November 1988, no money beyond 1,57,000 was required to be paid, but still on good gesture, the railways have always agreed to
Where is
pay
this
the amount, whatever.
letter of 18/2/1988? Where is this letter?
Page 24. Page 24, my lord,
24 of what?
of the writ petition. This is the communication, my lord. Page 25 is the type copy, my lord. Page 24 is the, it's not clear, my lord. 25 is the type copy.
24. This is 18 February.
18 February 86, my lord. It is addressed by the Additional Deputy Commissioner to the Chief Engineer.
And this is not the payment part. Where is the?
My lord, here there is a that the railways will not be required to pay any amount over and above the assessed amount of 1,57,000 in respect of the said line while transferring the same.
We are interested in this letter of the letter which you have mentioned in the second part of paragraph 5. Two letters, 1/12 to 1987 and 18/12 to 1988. If there are records, State Council will go by the records. Your denial by an deponent who is not abreast with the records, we may not consider it.
My lord, after 34 years, my lord, can they say that amount has not been paid?
I would like to have these two things, 1/12/87 and 18/2/1988. You have made this statement based on the record, Mr. Gupta, isn't it?
Yes.
So you
Yes,
have
my lord.
those two letters.
Yes.
And let the petitioner also be satisfied.
Lord.
And you would also like to have the verification done, okay?
Yes, my lord.
Third, Sri
May I please, your lordship?
we're not disposing of, we are just giving him a direction.
Okay, my lord.
Land Council for the petitioner. Also heard Sri H. Gupta, that CGC, appearing for the railways online. Whereas Sri Land State Council is present for the state respondents. Para? While the Learned Council for the petitioner has contended that no compensation of any manner except for a petty amount of rupees 11,950 for crops damage
Lord.
has been paid, comma, the Sri Gupta, the learned learned CGC has submitted that an amount of rupees 1,57,000 was assessed and paid to the Deputy Commissioner of the concerned district, full stop. The aforesaid aspect, however, has been denied on affidavit by the affidavit filed on behalf of the state respondent numbers 2, 3, 4, and 8. And paragraph 5 thereof. In this connection, comma, the statements made in paragraph 5 thereof are extracted here and below. Oh, no, don't say. Which are categorically, okay, what is the last line? Last line? No, just put the last line enter. The aforesaid aspect has been categorically denied by the respondent members. So and so in the affidavit filed, what was it? No, don't say that prior to that. Five to 4 filed, and in this connection, the averments made in paragraph 5 have been pressed into service. Full stop. Para. Sri Gupta, the Learned Council, has, however, submitted that in the affidavit filed by the railways, there is a mention of two communications of 1987 as well as 1988, which would show that payment was indeed made. Full stop. Para. Since copies of the aforesaid two communications are not available in record before this court, comma, Sri Gupta.
My lord, these are available on record. My lord. These are part of the repetition.
Where? 87 and 88? Where?
It is there, my lord.
Page?
Annexure, page 25 was the first one, and no.
Page?
18 to 86, my lord.
We are interested in two letters, 1/12/1987 and 18/2/1988. Where is it?
My lord, 18 to 1988 is, my lord, writ petition annexure C. Annexure C, my lord, page 24. It
This
has
is
been,
into 1986, they have said.
my lord, it has been wrongly typed. It is 88 only, my lord. In the writ petition, the unclear copy is 88. Annexure C is 18/12/1988, and my lord, annexure F is 1/12/1987.
Picture?
Annexure F, page 32, my lord.
32. 112.
1/12.
These are there.
These are there, my lord.
Where is the clear copy of page 32?
At page 34, my lord.
How do you deny this communication, Mr. State Council? Two communications are there. I think this date is confusing, Mr. Council. This page, it should not be 88, it should be 86, I think. Isn't it? At page, where is that page?
24, Lord.
25.
Type copy 25, Lord.
It's not 86 perhaps, it is 88.
88, my lord.
But if they have said that in spite of this, they have not received, that means the money is lying in the office of the Deputy Commissioner.
But my lord, in the affidavit, it clearly says that they have ascertained and there is no record that payment has been made, my lord.
How have you verified the affidavit? Let us see.
But regard to these communications, no response is there. Yes, paragraph 5 is contradiction with all these communications which I have referred, my lord. Because it does not mention about the fact of assessment of 157 and whether it was paid or not paid.
Couldn't being matters. It will be a difficult position. How do you ascertain? Factual disputes are there. At the same time, you cannot deprive them. If they are affected person, we cannot deprive them of their rights, their interest.
May I please, your lordship? My lord, your lordship, may kindly see page 55.
Do you have the records, whatever, do you have the records?
No, I don't know.
Then from where did you prepare the affidavit?
No, my lord, it was sent as per the instruction given by the
No.
state agency.
You do not have it today. The instructions definitely would have been given to you based on the records.
Yes.
Please ask the records to be transmitted to you. We'd like to have a look at the records.
Your lordship, may kindly see the letter dated 0/010/1982.
Page?
Page number 55 in the writ petition, my lord.
Yes. What is there?
Joint survey.
You get the records. There are confusion. We don't like the
Joint survey, my lord, subsequently it is.
last part you have to check, cancel. No, don't just cancel. Just read the entire order. Read the entire order.
Except for the amount of this for the should be covered as the by the loan of the risk of 187. Was assessed when made the definition of the operation.
Full stop. Then? Denied. Has been pressed into service. Then you don't write the lines. Pressed into service. Full stop. Para. Since a factual dispute has arisen, comma, the London State Council is directed to obtain the records of the case based on which the affidavit was prepared and filed. Full stop. When can we have this case?
My lord, after 3 weeks, my lord.
Not 3 weeks.
My lord, now the strike is going on, so
What
it
strike?
is indefinite, my lord. All the offices.
But we
went
fix
on,
a
my lord.
date,
And
we
my-
try to fix a date. Please, Tom. Tell us, today is what? 20?
28, Lordship. It is 28.
Excuse me.
24/11, my lord.
Can we have it on
Gonna-
18? Oh no, 24/11.
Yes,
That'll be too long.
because till 21, I have
It is 27th, isn't it?
Yes, my lord.
1, 2, 3, 17th we'll have.
My lord,
17th November.
24, my lord, because till 21, I have some
Okay.
difficulties, my
Okay,
lord.
24/11.
Yes, my lord.
Okay, we'll try on 24. But if factual disputes are there, it will be difficult for a writ court. Because we have to go on the basis of facts which are admitted. Now, there are certain facts which appears to be disputed facts, but those are corrected by those will be clarified from the records. Here, the dispute is between the respondents themselves.
Lordship.
Okay, we'll try. Okay. Next, please.
Much obliged.
For hearing, item number 20.
Keep this in order, huh? There's a one here and there. Yes, what is this?
May I please, your lordship? Lordship, the present petition is against the order in original passed where the GST has been levied upon the petitioner for the works executed by the petitioner for Dimapur-Kohima National Highway. The assessment order has been impugned on the ground that it has been passed by levying tax upon the petitioner, which shall amount to double taxation, and which is not permissible under the Constitution.
Why double taxation?
Double taxation because, Lordship, this is a works contract executed by a joint venture of which I am one of the constituent partner.
Yes.
We had divided the work among ourselves, and the assessing authority.
You're a joint venture.
I am a joint venture. The petitioner is not a joint venture. Petitioner is one of the constituent of the joint venture.
Okay, then.
The joint venture was awarded a works for construction of four-way national highway from Dimapur to Kohima by the National Highway Authorities of India.
Yes.
We had executed a work.
Yeah, for the GST.
Yes, sir.
The joint venture had executed a work where the work was divided between one of the constituent, that is Ramki, and myself, the petitioner hearing, that is ECI. The ECI had executed major part of the work, and Ramki had looked after the project managements.
Yes.
Now what has happened? The assessing authority has taken an interpretation that joint venture, including its two constituents, that is Ramki and the petitioner herein, ECI, all three have their three separate GST registrations. So all the three of them has to pay the GST.
Who is the third partner?
It's Ramki, ECI Engineering, the petitioner herein, and the joint venture, which is Ramki ECI JV.
Okay.
The assessing authority is of the interpretation that since these three entities has three different registration under the GST, so all three of them has to pay the GST.
Okay.
Whereas the works contract is one common works contract which has been executed by the joint venture.
Yes.
So the tax can be levied only once in the entire transaction, where the ultimate receiver of.
But what is the component of the tax?
The component of the tax is the total supply of material and services which have been done from the joint venture to the National Highway Authorities. The National Highway Authorities is the receiver of the total supply, and the supplier is the joint venture.
Yes.
So the value of the contract which has been executed is the component on which GST is to be levied.
Yes.
That GST has already been paid by the joint venture, which is an admitted fact. However, the assessing authority has taken
The tax, the levy which the joint venture has discharged,
yes,
it will take care of all the components of the work.
all the entire component of the work. I'll come to Lordship the interpretation of works contract and the interpretation given by the Honorable Supreme Court in that regard, where it says that the works contract is a composite contract and all the parties who are involved in the works contract amounts to one common transaction.
Yes, what do you say?
Your Lordship, first of all, Your Lordship, if we can see the Annexure 1, the order which has been impugned in this case, Your Honor.
Yes.
Page number 29, Annexure 1.
Page number?
29, Annexure 1.
29. We'll come back to you, Mr. Todi. Just a minute. Just we want to have a...
The first preliminary objections.
Yes.
May I read, Your Lordship?
There's an appellable order.
Yes, Your Lordship. It's clear in this.
Why don't you prefer an appeal? These are matters which will involve the expertise of the authorities.
Yes,
Lordship, because there is a clearly a jurisdictional error. And
No,
when
you
there is a
take
jurisdictional error, it may not be a bar.
No, you are not saying it's a bar.
Lordship.
We are only on the aspect of an expertise, an appellate authority which is specially meant under the, which has specifically been constituted under the statute. And this jurisdictional issue, you can take it up.
Yes, Your Lordship. It's clear from the order also, Your Lordship. Paragraph 1A.
We have seen the order.
Paragraph, may I read, Your Lordship? This copy is granted free of charge.
If it's very, very onerous upon you to approach the appellate authority, we are not even making any comment of any bar coming to the writ court, because you may be covered by whirlpool exceptions and the other clarificatory decisions. But if the appellate authority would be a competent authority, efficacious authority to effectively address your grievance, well, you go there.
Yes, Your Lordship.
You go there.
Paragraph.
You don't say anything on merits, you may have a good case. Instead of canvassing your points here, arguing your case here, you can argue before the appellate authority.
But so far, Lordship, the clearly jurisdictional error. So the petitioner.
If we say something about the jurisdictional error against you,
Lordship,
it will be a difficult proposition for you to, and you send you to the appellate authority on the merits of the case. If we agree with you, matter ends there.
Lordship.
But if we do not agree with you, and definitely I don't know, he must be prepared on merits also. This is the first point he's trying to point out.
Yes, sir.
The aspect of, what is the order of admission?
That is Lordship.
You are being protected.
Lordship protected.
We'll have the protection till you. Is there any time limit for the appeal? There must be.
Time limit is already over.
Oh, no, we'll as a writ code will clarify that.
Lordship.
We'll clarify that. And an interim order will be there till adjudication of the appeal. Since this order was passed when? Interim order was passed on which year?
18/1/2024.
This will not make too much of prejudice to this since it's continuing since a year. We'll direct the continuation of the interim order till a final decision is taken by the appellate authority, and it will depend on the final outcome. Third, Dr. A. Todi, learned counsel for the petitioner who is aggrieved by an order dated 23/8/2023. Order in original, dated 23/8/2023, passed by who is the authority?
Additional Commissioner.
Additional Commissioner, GST.
Dimapur.
GST, Dimapur. Please have your seat. Also heard, Sri, your name, huh?
Zakuna.
Learned Standing Counsel.
Standing Counsel.
GST.
Yes, sir.
State GST.
CBIC, Rosh. Central Board of CBIC. Standing Counsel for CBIC.
Central Counsel CBIC. Parent? It has been contended that the petitioner is a constituent of a joint venture which was entrusted with the work of construction of the national highway from Dimapur to Kohima. Full stop. It is also submitted that the two constituent, namely the petitioner, comma, its partner Ramki, and the joint venture as such had 3 separate registration under the GST. Full stop. While the case of the petitioner is that the levy under the GST has been made from the joint venture, comma, a separate levy has been sought to be made from the petitioner, which would amount to double taxation. Full stop. The Learned Council has also raised a serious issue on the jurisdiction of the authority who had passed the impugned order. Para? Sri Swenson, Learned Standing Council has, however, raised a preliminary objection that the order impugned is an appealable order, full stop. By drawing the attention of this court to the impugned order, comma, the Learned State Council has submitted that the aforesaid aspect has in fact been clearly reflected in the order, which not only has apprised the assessee about the provision for appeal, but has also named the appellate authority. Full stop. Para. Dr. Todi, the Learned Council has, however, responded that since a jurisdictional issue is involved, comma, there may not be any bar in approaching a writ court. Full stop. Para. After hearing the Learned Council for the parties, comma, while this court would agree with the contention advanced on behalf of the petitioner that there may not be an absolute bar in approaching the writ court, more particularly in view of the principles laid down by the Honorable Supreme Court in the case of Whirlpool so and so, 1988, so you give the citation, comma, the said issue can also be raised, the said jurisdictional issue can also be raised before the appellate authority. Full stop. This court is also of the view that the dispute would be with regard to technical aspects wherein expertise, knowledge would be required, and for that reason only an appellate forum has been provided in the statute holding the field. Full stop. In view of the above, comma, this court this court is of the opinion that instead of the dispute being raised in this court under Article 227 of the Constitution of India, comma, the same be raised before the appellate authority in terms of the statute holding the field and before the appellate authority who have been named in the impugned order itself. Full stop. At this stage, comma, Dr. Todi has raised the issue of limitation, has expressed that the issue of limitation may come in. Full stop. This court, in exercise of its equity jurisdiction, directs that if the appeal is preferred within a period of 45 days.
3 months, not so.
No. You will raise the appeal.
Yes, appeal filing is otherwise 3 months from the date of appeal.
It's already gone. Raised within a period of 60 days from today.
60.
Comma. No, why 60 days? You don't need so much time to prepare an appeal. From 45 days from today, comma, the aspect of limitation would not come into the way of its adjudication on merits. Full stop. This court also clarifies that while the writ petition is being disposed of, comma, no opinion has been rendered by this court which would affect the interest of the rival parties, and the appeal is to be decided on its own merits. full stop. Since an interim order is operating, comma, to balance the equities, comma, it is provided that till the appeal is disposed of, the interim order passed by this court on
18/1/2024.
on
18/1/2024.
18/1/22 shall be kept operative. Full stop. I'll give you the citation of Whirlpool. Can you give the citation of Whirlpool?
1998 8 SCC 1.
One. Give the full name, registrar.
Whirlpool Corporation versus Register of Trademarks, Mumbai and others.
That's all.
Right.